Lara Yeretsian, Lara, great to see you again. Thank you so much for joining me tonight.
Good to be with you, Michael.
Absolutely. Let me ask you this. All right, there's a lot to discuss with this guy on the stand. I don't want to stick to his direct right now. We'll get to his cross a little bit later. Now, on direct, I thought he was a little bit all over the place. I thought he was throwing everything against the wall that he could and see what would stick. Your thoughts on how he did and if he actually helped himself on direct?
On direct, he's good, but even on direct, I have to admit, as I was watching, he's thinking a lot. He just doesn't forget about what he's even saying. Just overall, his demeanor and behavior and the way he's talking. If I was on a jury, I'd be looking at everything he's doing and saying, and something about him is just not very believable. We've seen other defendants before in other cases, and they've been convincing. His seems like he's been rehearsed and he's thinking through it. It's just not very convincing for me.
Yeah,
I don't think he did that great.
Yeah, I agree. I don't think he did that great. You know, there was some suggestion that perhaps he hadn't been prepared properly because he mentioned that the shooting might have been an accident. And again, we'll discuss that in a second. But I think it's the opposite. I think that might have been a surprise to the defense because clearly if they knew he was going to say something like that, they would have told him not to say it. But he was so over-rehearsed to me that there were these taglines that he kept saying over and over again that he wanted to reiterate. He kept trying to create this sort of sense of how the racial injustice and all these other things. And I was thinking of Arbery, I was thinking of Floyd. It's just hard to believe during those tense moments of what was going on that all these things went through his head. And that's where I think he lost credibility for me.
I agree with you, and I think he overdid it there. And anybody who's been thinking about all those things would not have gone next to the car and punched this individual. That's what's going to come back and haunt him, I have to admit. I was thinking about all of that, and I thought anybody who's that worried, that concerned about the environment, the racial issues that we were having at the time would not have even taken that first step. But I mean, he's saying, I agree, I should have never done that. Had I known this in hindsight, I would have never done that. But again, it just takes away what he did, takes away from what he claims got him to the point of getting into that accident or accidental shooting, which again is going to be a problem because up until now, we were under the impression that this was done in self-defense and that it was not necessarily an accidental firing.
Yeah, so let's get into that. He actually says that the guy lunged at him, right? So he begins to mirror the testimony of Kyle Rittenhouse that he lunged at him. Up to this point, we've heard from eyewitnesses. None of them said that they saw any kind of lunge. One did say that it looks like he got squatted down or the victim squatted down into a sort of a boxing stance, but no lunge. He says there was a lunge. He thought he might be reaching for a weapon, again, mirroring the testimony we heard from Rittenhouse. But the problem is, it's a self-defense case, right? And so there had to be this intentional shooting to claim self-defense. Prosecution tries to capitalize on it, saying that they don't want the self-defense instruction because he claims on the stand it was an accident. So that really could put a sort of a crimp in this case.
Agreed. I mean, it's pretty confusing at this point. Which one is it? Is it self-defense or is this accidental? Was he thinking about shooting, but it happened accident? I mean, the whole thing is just up in the air, and I'm not really sure if the defense expected this or maybe they did know and they just let him say it because they didn't think they had enough for self-defense. A lot of it is up in the air for me. Honestly, it's not very clear, but it does take away from the self-defense too. I mean, you're arguing self-defense, but at the same time you're saying, I didn't really do it. It was an accident. So then you didn't need to do it at that moment then. You didn't have enough to worry to actually shoot at the individual. It happened accidentally. I mean, the whole thing is, I don't want to, this is not the equivalent of the Kyle Rittenhouse case, I can tell you that.
Yeah, absolutely. Those parallels are certainly not there in terms of the facts of the case. He also said something to the effect that the guy lunged at me, thought he was reaching for my gun. But then later on cross, he says something to the effect that when the victim raised his arms, he thought he had a weapon in his hand. I mean, he was just throwing everything out there possible to seek this justification for his actions. And again, I don't know. And even Joy said this jury began to look a bit skeptical. All right, Lara, stand by.
Does that surprise us?
Yeah, not right.
Doesn't surprise us.
Doesn't surprise at all. All right, Lara, stand by. We're going to take a quick break now. All right, still with me, criminal defense attorney Lara Yeretsian. And Lara, there's the problem. I mean, you could see it pointed out very clearly there by the prosecutor. We have a number of eyewitnesses who testified to what happened between the two of them. We have the video. Now, the video is not the clearest thing in the world, but it doesn't, at least to my eyes, support what he's saying on the stand right now. And certainly, it doesn't match up with what we heard from eyewitnesses, and that's going to be problematic for him.
Oh my goodness, it's going to be problematic. I mean, it's pretty obvious. There's four witnesses who say his hand went up, and it wasn't just a reactionary going up. That's pretty clear. Reactionary is where when you're moving backwards, your hand slightly goes up. I mean, this had to go up really high to hit Clearman in the eye, in the face. And I mean, he tried to answer that, but he didn't really have a good answer. This lunging forward was not enough. You've got four witnesses who saw this. You've got a video that doesn't discredit these witnesses and what they saw. And you've got a problem. He should have stuck to his original story, which was this was in self-defense. He might have had a much better shot than saying that this was an accident, because his statement that it was an accident is really not believable.
Yeah, and you know, it just sort of goes against all that his defense has been arguing up to this point, which again raises questions. The other issue that this jury got to hear a lot about on cross-examination was the fact that he fled. And we know that there's going to be a jury instruction that says they can look at that and interpret it as consciousness of guilt. And it talks all about what he did. And he tried to claim that he was looking for an attorney, trying to raise some money. But again, it doesn't line up with his actions. So that's another hurdle that he's going to have to overcome in terms of what this jury is going to be deliberating about.
Correct. When someone flees, that's considered, I mean, the jury consider that as a consciousness of guilt type evidence, which is exactly what the jury instruction is going to say. Now, is there a way to explain that away? Maybe there is. I mean, people get scared. It doesn't necessarily mean that they're guilty. People can get scared and flee because they don't want to be in custody. They don't want to have to, they don't want to be in the system defending against serious charges like this. The whole experience, the entire experience can be horrific. And so the defense maybe can explain it in different ways and can explain that, you know, he was trying to raise money and he was trying to get a lawyer. And whatever the explanation is. But at the same time, the jury, if they don't find him very credible on the rest of his testimony, will see this as evidence of consciousness of guilt.
Absolutely. Do you think you would have been better off not taking the stand at all, Lara?
Maybe. In this case, he did need to take the stand because the argument or the defense was self-defense. No one else can explain it better than him. But honestly, the way he did on the stand is so bad that maybe he would have been better off not taking the stand.
Yeah, I think they had a solid case without him taking the stand, but they made that promise from opening statements, so you have to deliver at that point. And again, you got to know your defendant. I think getting to know him now seems like it might have been a better choice not to put him on the stand. Let me bring back in my guest, criminal defense attorney Lara Yeretsian. All right, Lara, you have the state case, and we saw that they were successful against Chauvin. They decided to go with the federal case first against the other three officers. Do you see this case being more difficult to prove than the state case against the officers?
Definitely. The federal case is very different. The state case is very direct. It's easy to argue. I mean, it's more about what Chauvin did in that case, or what, in this case, these three officers, whether they aided and abetted Chauvin in the second-degree murder or the manslaughter. And that's very straightforward. The federal case is a little more complicated, more nuanced. It's about a civil right, a right that the victim, in this case George Floyd, had, and how these officers deprived them of that right under the color of law. And under the color of law is basically them being officers. So it's not as direct. It's not as easy to explain. And you are in a federal courtroom. Things are a lot more formal and under control. The judges have a lot more control over the way the proceedings are held. They're usually shorter, tighter, less emotion. Those are advantages that the prosecution had. The emotional aspect, the prosecution had that in the state case. They won't have as much of it in this case as we're seeing and as you talked about earlier.
Yeah.